Legal 115, this is your podcast for Section 3 of the course. And in this section, we are going to begin discussing estate planning. A will is the document that controls the disposition of a person's property at death. And in Illinois, the maker of the will must be 18 years of age, be of sound mind and memory. The will must be in writing. The will must be signed by the maker and must be witnessed by 2 witnesses in the special manner as provided by the statute. Persons who have an interest, people who are interested parties who are beneficiaries of the will, cannot serve as witnesses. So it has to be non-interested or disinterested, I should say, witnesses. The will has no effect until the testator's death, and at the testator's death, the will is presented to the court. It's filed with the court, and after it's proven valid, it's put into effect and its provisions can be carried out. And we'll cover this later in the semester when we explore the probate process. A will lets you give your property to the people or to the interest of your choice. And we've covered intestate succession, so this is a contrast from intestate succession. But keeping in mind what we learned with intestate succession and what we learned regarding property in the week prior to that, a will generally does not control the disposition of the following properties: property held in joint tenancy, property payable to a designated beneficiary, property that's subject to transfer on death, deed, or payable on death, designation on a bank or an investment account, or property held in trust. And if that didn't make sense to you, you can go back to your notes and the materials from when we discussed property. Now, regarding a will, there are some considerations in making or reviewing a will. For instance, who should receive the property? And if they're children, at what age? Because minors can't receive property. Minors would have to have a trust or contingent trust set up and someone appointed as a guardian of their property, and most likely their person if the parents aren't around. Who should be named the executor? Who should be named the guardians of those minors' children and what their duties are? If a trust is to be created for a spouse, for children, or others, you have to name a competent individual or trust company to manage that trust property. Are there any charitable gifts to be made? Should life insurance proceeds be payable to a trustee or executor named in your will or to individuals directly? Can taxes be avoided? Has the marital status changed since the last will? Have any beneficiaries of the estate died, or are they, is the will subject to any important changes in circumstances or assets because of death or some other change since the will was created? And remember, many of you may have experienced this or have done so yourself. You create a will and then your life changes in some way. Marriages end, people die, beneficiaries die. Things that you wanted to do with your property may change based on a lot of different considerations. And then finally, we always go back to what we learned when we studied the law of property. Remember the types of property, how property can be owned, and how certain property can be owned or titled so it passes to someone else without a will or without the need to involve the probate court. Ideally, when we're talking about estate planning, we plan the estate so that the will is more or less the safety net. In other words, I want my will to be that document that if, despite all the best efforts at planning, we still had property that was not passed outside of probate. It didn't pass directly to beneficiaries. It didn't pass to an entity or in the path that we had hoped, that there is something that helps us there. Now, I asked you to read an article from the ISBA, and that article, in fact, I think I asked you to read it once, twice, as many times as you need. That article essentially outlines what I just said about wills and more. It talks about a little bit about the taxes. It makes it clear that, making a will isn't really that expensive. And it breaks down some of the other considerations about avoiding probate, the advantages of probate, the advantages of avoiding probate, and all of the terms. I think it's going to depend on your situation and how complicated sometimes your situation is or a client's situation is. I've always been of the mindset that, and it's what I was taught, that you look at advice from anybody who's relevant in that client's life regarding their assets. So, thinking back to that ISBA article, it starts out with your estate planning documents and references, life insurance and retirement plans and IRAs and any business documents or anything that's related to accounting. If in talking to that client, if they have these other things, I would probably consult with, for instance, their insurance and financial representatives, with their bankers, with their people that maybe if they owned a business in a family business or something like that, consult with their business lawyer or their business accountant for sure. If they have an accountant, if their life is complicated enough that they have a tax accountant, if they were more than like the rest of us using H&R Block or filing on our own, I would talk to those other professionals, in other words, and get information. Of course, we get the client's permission to do that, and get their opinions also on the client's intention regarding any particular aspect of their property. But keep in mind that our goal in estate planning is to take the client's property as they have it at this moment, preserve that property so that the client can use and enjoy that property, and then do with that property what the client would like to have done with that property at the time that they pass away. And that could depend on a lot of different things. It will definitely depend on the type of property. It will definitely depend on the value of the property. The article covers tax considerations. That's something that I always defer to an accountant on. Occasionally, we have a lawyer who is also a tax accountant. Those are rare, so we defer to those other professionals. What's the end result of that property, or the result that the client wants to have that property serve. For instance, most instances in a marriage, if there's a marital home, the parties would like, or the person involved in the will would like that property to go to their surviving spouse. Well, we can look at the deed. That may already be done, right? We talked about how we hold real estate. So if it's held in joint tenancy, then it's not going to be probated. Insurance proceeds. We make sure that whatever their wishes are, that the beneficiary statements in the insurance policy match those intentions. Well, that insurance money is not going to come into the estate. It won't be probated. It doesn't get impacted by the will per se. So as many things as we can have passed on in a different way outside of the will, we do that. One other thing that I should note, and I don't know that I have so far, some people are confused. For instance, when you have a married couple, in fact, I've had people who I've created wills for who came in as a couple. Initial consultation, they believe that they have one will, or their wills have to match, and that is not the case. And our practice was always to divide those people up and consult with them individually and make it clear that they each would be creating a will, and those wills did not have to match up as husband and wife. They could have different distributions or intentions regarding the property that was their property, individual property. Whatever is left at the time of their death that was their individual property. Obviously, if they had a house in joint tenancy, etc., those things, that's not a worry for the will, but keep this in mind as that example. Someone could be joint tenants on a marital home, and one party passes away before the other, which is typical, right? And so that remaining spouse is the person who now owns that property. Occasionally you run into the circumstance where they don't do anything with the deed. They just keep living in the house, and nobody's ever done anything with the deed, and the deed still says to the two parties in joint tenancy, and the first spouse has passed away long ago. Well, that property was owned at the time by that remaining spouse. If they haven't done anything with that property to change the status of that property is going to go into, or need to be probated by way of their will if they have a will, or it goes in intestate succession, right? If they don't have a will. So a will is, in my view of what a will is in estate planning, it is the safety net. And I like to think of estate planning as an opportunity to keep an idea of what you want to happen with your property, always with that idea that the property should be maintained and usable for that person during their lifetime, but then passes to whoever or however, whatever entity that individual would like, preferably without having to go to the probate court. Well, I think that article and other resources, and I, in fact, would agree that a will is not expensive to create, and probate generally, unless you have people that fight in probate, people that want to fight about property of loved ones, which happens, generally is not that costly. It can be a bit of time, and it is some work for whoever is left to be the executor. If you've served in that role, you know what I'm talking about. You essentially take on the life of the person who's now deceased as if it were your own, in all the ways that we deal with life in managing our own property and resources, etc., including paying their income tax. So, not that you're responsible for it, but you just have to do all the work. So for estate planning, I think that's the focus you need to keep. And for wills in particular, as an estate planning tool, you need to really think of it as that safety net. It's something that would be valuable to have, but ideally, you don't need it for much, okay? You're not catching a lot and having to deal with a lot within that safety net. It's certainly able to be something that can happen, but it takes planning. And again, in closing, just consider what type of property does your client have? Who are the other professionals that might be able to provide opinions or some ideas about how that property can be better distributed in the vein of the client's wishes? And then also remember that you're going to need those people, because if you decide, for instance, or the client decides that they want to pass life insurance proceeds or investments or whatever to loved ones in a certain way, that is likely able to be done with some beneficiary statements or some sort of documentation from that entity that holds those investments or insurance, by making sure that whatever forms are necessary for that purpose are filled out and contain the language that you help create as the legal professionals and they find acceptable as the entity that's ultimately going to distribute that property to whoever it's to go to at the time of death. We will take a look. Let me see here to just make sure. In greater detail at wills and drafting wills in the next section of the course. But you have a little bit of an introduction this week, or this section, as you consider estate planning and what that means. I appreciate your efforts so far in the course. I look forward to seeing what you post for this section. If you need me, you know how to find me.